U.S. versus Lopez case of 1995. The laws before the case was brought to court consisted of the Gun-Free School Zone Act of 1990. This act prohibits any person from knowingly possessing a firearm in which he or she believes is a school zone. It also prohibits an individual from discharging the firearm or attempting to discharge the firearm in a place he or she believes is a school zone. The GFSZA defines a school zone as in or on the grounds of a public, parochial, or private school, or within the distance of 1,000 feet of a public, parochial, or private school. There are some exceptions to having a firearm on school grounds. One is that the firearm possessors are licensed by the state or locality to possess the gun or obtained a state license in state or local law enforcement and is qualified to have this license, or it is where the firearm is unloaded and in a locked container or locked on a firearms rack in a motor vehicle. Another exception is to where the firearm possessor is hunting on school grounds when the school zone gave them authorization to hunt on their property. Why was Lopez brought to court is the main question in this court case. On March 12, 1992, Alfonso Lopez brought a gun to school. He was only 6 weeks short of graduation. He insisted that the .38 caliber gun was handed to him by a classmate with instructions to deliver it by someone else. He was arrested and charged under the Texas law with possession of a firearm in school grounds. Alfonso Lopez had no money for bail, no funds to hire a lawyer, and thanks to the law that Congress passed 2 years earlier that banned guns within 1,000 feet of a school, he had little chance of escaping the 6-month prison sentence that he was given. What happened during the court case of Lopez? The district court conducted a bench trial and found him guilty of violating the 922G and sentenced him to the 6 months in prison and 2 years of supervised release. The 922G was the court case of the Gun-Free School Zone Act. On appeal, the respondent challenged the conviction. He claimed that the GFSZA exceeded Congress's power to legislate under the Commerce Clause. What was the outcome of the case? The Fifth Court reviewed the act and stated that it exceeded Congress's power under the Commerce Clause. Therefore, it was unconstitutional. The Supreme Court then held that the GFSZA exceeded the Commerce Clause power of the Congress, and that there is no sense in economic activity with the possession of a gun in a local school zone. They pretty much said that it has nothing to do with Commerce Clause and any sort of economic enterprise. Alfonso Lopez was also known as Big Al. He was born on February 18, 1933 and died December 18, 2011 on hospice care. After his court case was all said and done and everything turned out to be okay, Lopez went and served with the Marines and Army during the Korean conflict. He served with the Army because he felt it would be good for him because of what happened in high school and how he didn't get his diploma because he got charged with guns. He went to prison and felt that it would be good for him to go into the Marines where firearms are no longer a problem.
New laws consisting the U.S. versus Lopez. The new